welcome to this discussion today, which is the latest in our weekly PCD-led member sessions. Today we're going to be taking on the topic of UK-Spain cross-border wealth planning. We've got a panel of experts from London and Madrid to bring you the latest information from a tax and legal perspective for private clients planning between the jurisdictions. So we're sure of a very interesting session today. As always, joined by two audiences. We have PCD members here with us on Zoom. We also have an audience on YouTube who are following on the live stream. We're going to have a discussion today over the next 60 minutes. And in the last 10 minutes of that hour, we're going to cut the feed to YouTube. We're going to say goodbye to our YouTube audience, and we're going to do some networking and chat with our panel, with our PCD member audience. But both audiences are very welcome today, very welcome to ask questions. We'll be looking for those actively in the chat, pick them up and put them to our panel as we move through this very interesting discussion. So to open up, this is going to be a game of two halves, this conversation. First of all, we're going to look at the British clients either considering or having moved already to Spain. We're going to look through all the considerations there. Then we're going to see the reverse with Spanish residency and investment back into the UK as a way of discussing all the latest topics and considerations. So to open up this discussion, focusing first on British people considering or looking at a move to Spain, I'd like to welcome Constantino Vidal, who's a tax partner in Madrid. Good afternoon, Constantino.
Good afternoon, David, and thank you very much for inviting me to this webinar.
Fantastic. So perhaps we're going to focus today on the tax aspect. So immigration has got more complex since Brexit. That's partly a conversation for another day. Really, it's today we're going to look at the major
Definitely.
tax planning elements. And so perhaps just to kick us off, you could explain a little bit about the tax environment that UK families moving to Spain would find themselves in.
Yeah. So first of all, what they should consider moving to Spain will be the tax residency. So spending here in Spain more than 183 days will consider them as Spanish tax residents, which means that they should consider it for both income and wealth tax purposes, which means that for both taxes, they will be considered as taxpayers, and their worldwide income and wealth will be taxable in Spain. And also there will be consequences from the inheritance tax as well, and also regarding the information obligations, the famous 720 tax return, which is a tax return where you inform about your wealth overseas, which is a very, very important tax return. Well, it was. Right now it's a little bit easier, but it was very, very, very important, and its consequences were really, really bad for the Spanish taxpayers. So basically, in a nutshell, what you have to consider is, okay, I'm going to spend in Spain more than 50% of the year, so I will be considered a tax resident there. So my worldwide income and wealth shall be subject to taxation in Spain.
And is that from day one? Is it as soon as they arrive as resident, you've got a worldwide tax position, or is there any demarcation between pre-existing wealth and wealth that is then generated while resident in the country?
Well, the first consideration that we have to do is that we have to keep in mind is that the fiscal year in Spain is the natural year, so it's different from the British fiscal year, and you can be considered a tax resident for the whole year, which means that if you are not in Spain right now and it's May, but it's May the 12th, but you are here next week, you will be considered a tax resident in Spain for the whole year. So there is no possibility to do or to apply the split year as in the UK, but you cannot. In Spain, you are a taxpayer for the whole year. So you are a tax resident for the whole year.
Okay, and those arriving with pre-existing wealth, then do they? Is there any typical planning that you see people using coming from the UK? Whether it's perhaps taking dividends, triggering gains, or is every case different in its features?
Well, it's any case is different for sure, but the main the main regime that we are applying is the so-called Beckham law, which is a special regime for citizens coming to Spain that haven't been a tax resident in Spain for the last 10 years, and they can apply it for the year that they move to Spain and the following 5 years. So the considerations to be met here are that you have to move to Spain for because you have an employment offer, and the main consequence is that you will only pay taxes for your Spanish source income, which basically will be the employment income, and any capital gain, dividend, or whatever obtained overseas won't be taxable in Spain, which is very, very interesting. So your income or your assets generating income overseas won't be subject to taxation in Spain, and it's the same with your net wealth, which means that only your Spanish wealth will be subject to the wealth tax as well, which means that your overseas wealth won't be subject to wealth tax in Spain.
So is that an interesting opportunity for entrepreneurs or people who can create an opportunity to set up a business and run a business from Spain? Well, is it more complicated than that?
It's more complicated because if you set up a company, you will only have to have shares for up to 25% of that company, which makes things more complicated. So if you have partners, that will be an opportunity. But if you are a lonely entrepreneur, that won't be the case. You won't be applicable. You won't be eligible to apply this special regime.
Okay, so it seems quite complicated then to engineer the scenario. It's either you have that available or not, as it were. So what kind of steps then do people take in terms of planning around inheritance and gifts? If people are coming with wealth, perhaps for retirement, what
so basically, it's also very important to consider here that the typical trust structure that it's very, very used in the common law jurisdictions doesn't work in Spain, and basically because Spain is not part of the Hague Convention, and the relationships between the settlor and the trustee and the beneficiaries won't be considered. So it's important to note or to point out that these kind of structures are very linked to residency and very linked to, for sure, inheritance and gift tax in the Spanish tax legislation. So basically, the scheme that we work with, or the more used scheme in this scenario, is set up with life insurance policies, basically with the unit link.
Okay. So a UK couple might set up a policy while they're in the UK that's tax efficient for their investments while they're there, and if they move to Spain, that policy, if given the right, it's in the right format, will be a useful wealth planning tool for them as they become Spanish resident, perhaps in certain circumstances.
Yeah, that will be right, but that's something that we should, we will recommend to review previously to this movement, and because it's something that we can manage once the movement has been done to Spain, instead of, okay, I have this situation and now I'm going to move. Maybe it will be better because of the life insurance regulation in Spain. It will be, at some point, it will be better to use maybe not a British insurance. Maybe we could work with Luxembourg insurance or a Irish insurance as well.
Yeah, which is very common in the UK for people to use the offshore bonds, which would have application over there. But British clients would be familiar with the idea of paying inheritance tax, but they might not be familiar with gift tax, and they might not be familiar with the way inheritance tax might apply in the UK versus Spain. So what do you find in that arena that people get caught out by?
Yeah, sure. So first of all, regarding the inheritance tax, it applies to both inheritance and gift tax. We have here different legislations to be applied, not only the Spanish law to apply, but we also have the regions law. And depending on the case, we have to use or apply different rules. And depending on which regions law applies, the difference the taxation will be. So basically, Madrid, that is where I am based, has several tax benefits to apply regarding gifts and inheritance tax, regarding gifts and between parents and children, and families with and couples, basically, and marriage.
So there can be a mismatch between the way in the UK there's reliefs for gifts between husband and wife, and there's an issue with making gifts down the generations, but the different rules apply, and matching those together must be complex.
Well, will be definitely, because it depends not only on the region where you're living, but it also depends on the asset. So basically, if you are receiving or donating a real estate property, the law to apply will be the law of that region where the real estate asset is located. If you are donating cash, the rule to apply will be the rule of the region where the who receives the gift is located. So it depends on the donor, on the asset, and on the person who receives the gift. So different rules depending on different scenarios.
But it's clearly important to look at this carefully before perhaps making a move, because the scenario just looking in the UK would be more vanilla. It might be advantageous, it might be negative. So it's a case of taking that advice part of the relocation.
No, definitely, because you only have you have to consider that you only have 30 days to submit the tax return. So once the gift is done, the picture is taken. So there is nothing else to do.
Okay, thank you. And on the trust side, if someone is a beneficiary of a trust that relocates to Spain, is it just a case of them reporting the tax that's due, and or do they often then leave the structure, or what tends to happen with those coming with existing trust that they might be beneficiary of?
So there is, as a general rule, we can say that there is no general rule, because different situations may apply depending on the trust, how the trust is set up. But basically, we could say that for sure we have to consider information obligations regarding the trust, and it will be the case that you could be taxable on the income, on your personal income tax, or it could be considered as the gift. So you have to pay taxes as a gift for the income received. So it will depend on how the trust deed regulates the situation between the settlor and the beneficiary.
Okay, well, many thanks for that. Thank you very much, Constantino, for opening out this discussion. Do put your questions or comments in the chat. We can bring Constantino back on to answer them. But I just want to bring in now Paula Picker from Buckles in London. Welcome, Paula.
Thank you, David.
So you're a family law specialist, and just looking at this kind of case of the Brits moving to Spain, what kind of things might you discuss with clients who are looking at a move, or perhaps who are already there? What's the different family law considerations they might face?
Well, first of all, good afternoon, everyone, and thank you for joining us today. So if I were to advise a British couple moving to Spain, the first point or the first question that I will ask them is, which area of Spain are you moving? And why is it important to know that? Because as Constantino was mentioning, we have a system where we have a jurisdiction, Spanish jurisdiction, but we have different regional laws. So certain areas of Spain have the power to legislate on family law, and that might imply that different rights and obligations apply depending on whether you move to Madrid or to Barcelona or other areas of Spain. So that is essential in order to be able to advise clearly the client. And the second point is the couple married or unmarried? Because if the couple is married, then certain obligations or rights will arise. If they are not married, then different laws will apply. Okay. Once established these 2 points, we need to look at the fact that in Spain, all Spanish couples have matrimonial property regimes. I'm not sure if you're familiar with this concept, but essentially, a matrimonial property regime is a set of rules that apply from the moment of marriage, and they will determine how the assets that you acquire from the moment of marriage onwards will be owned by the parties, and in turn, the rules will determine how those assets are divided in the event of a divorce. We have matrimonial property regimes by default. So if the parties don't choose one will apply depending on the area of Spain that they are living, or you can choose one. The two common ones are community of assets and separation of assets. Community of assets, all the assets acquired from the moment of the marriage are jointly owned. Separation of assets, what is mine, what is yours. Why is important to mention that? Because if you are going to divorce in Spain, you will file proceedings for divorce. The court will deal with the issue of the divorce, the children, and maintenance in the same set of proceedings, but the assets will be divided in a separate proceeding unless it's done by agreement. And why is it important to take this into account? Because from the perspective of a British couple, under English law, we don't have matrimonial property regimes. Okay, it could be said that during the marriage, you have the equivalent of a separation of assets regime in the sense that you acquire the property in your name or sole names. There are no rules. But of course, at the time of the divorce, is completely the opposite. It's treating the assets as if they were in a community of assets regime where you put all the assets, matrimonial pot, and divide according to the circumstances. When you have a British couple that moved to Spain, they don't have a Spanish matrimonial property regime. From the Spanish perspective, English law will apply. And that's where the tricky point comes in, because you're asking a Spanish judge to distribute the assets of an English couple according to English law. And that is a problematic. Why? Because the rules that we have to divide those assets are rules that apply to Spanish matrimonial property regimes, not to English division of assets. So you might be in a position where if the wife, let's say the wife owns all the assets in the marriage, under Spanish law, the husband will not be entitled to anything. What happens with that? Well, that will leave the door open to the other party making a claim in the UK. So you might be divorcing in Spain, and after divorce, you might return to the English court to have the assets distributed as a result of not having received enough relief as a result of your divorce, then causing further litigation. If you want to stop me there to ask any questions, just
no. I suppose it's sort of say then, so what are the key? If you're an advisor with a British client looking at, if the marriage is there and it's a long marriage, it's very solid. Is there any preparation that people make? Are there any extra documents that people take? What kind of practical advice do people look at? Both maybe where there is a situation where they feel like there might be trouble ahead, and also in a scenario where things look fairly smooth, but you never know what might happen.
Yes, so the point of explaining this bit of a nightmare situation that they find it themselves is to precisely check on whether the parties have either a prenuptial agreement signed in the UK. If they don't, they should do it. They should sign an English prenuptial agreement, even if they're moving to Spain. Why am I saying this? Because even if they live in Spain, either of the parties could still file proceedings in the UK because of their English domicile. And therefore that leaves open the risk of the English court dealing with that. So it's important to protect yourselves, and not only to protect, but it's a matter of both parties knowing where they stand, okay? And in the event of a divorce, how the assets are going to be distributed, what can you expect? That avoids litigation, avoids expensive legal fees. So if they have a prenup, then I will, or a postnuptial. When I say prenup, I also refer to postnuptial agreement. It's signed after the marriage, but it's the same concept. If they do have this document, what I would advise is that they try to replicate this same agreement in Spain, in accordance with the Spanish law. Why? Because under Spanish law, prenuptial agreements are legally binding. This doesn't happen in the UK, but in Spain, they are. I mean, you will need to really challenge the document for a court not to apply it. And in my professional experience, I've never seen anyone manage doing that. There is only some formalities. The document needs to be signed before a Spanish notary public. So solicitors don't have the same powers as, Spanish lawyers don't have the same powers as English solicitors. So if they have the prenup, yes, go to Spain, have it signed before a Spanish notary public. Make sure that you obtain advice from a local lawyer or a Spanish lawyer as to ensure that it complies with the Spanish law. If you don't have one, then do one that is valid under England and Wales and in Spain as well.
Okay, so in the course of doing the pre-arrival tax planning with Constantino, take some advice, look at the family law position, look at a post-nup, prenup, and that will help give some certainty around that. I think that was very helpful. We've got a question for John Hilson I'm going to bring to Constantino. Thank you, John, for your question. It's just asking, given the new COVID flexible working from home, do you expect to see Brits moving to Spain, or those who spend some time in Spain working there remotely, perhaps on an employed basis? But what are the considerations for their residency? Are they going to become tax resident without realizing? What's the implications of that? What's your perspective, Constantino, on Brits spending more time in Spain?
Yeah, that's a very interesting question, actually, because we have this is a very common situation right now, and the Spanish tax authorities just issue a binding ruling about 2 weeks, 2 or 3 weeks ago, stating basically that if you are in Spain, you are here, you will be considered as a tax resident here. So regarding your income from the employment, we have to review the treaty signed between the UK and Spain. But basically, if you spend here all your time and you are working even remotely, but you are working in Spain, your employment income will only be taxable in Spain. That's a very interesting question, as I said, and that's something that we are going to see a huge increase in the future in countries like Spain, Portugal, Greece, Italy. I think that all these countries, we are going to welcome a lot of home workers that are from the UK for sure.
Okay, thank you. And there's an additional comment in the chat there from Katia just saying, has a case of a Spaniard employed in the UK moving back to Spain the summer working remotely. So yeah, the working remotely piece is going to play into your hands, I think, but it makes complexity then for companies employing people and then the individuals themselves and the tax obligations that flow from that. But thanks for setting that out. That's excellent. Just want to bring in now Alvaro Aznar from Buckles in London. Welcome, Alvaro.
Hello, David. Thank you.
So great to have you on today. So we're going to reverse the situation now and really look at, in some detail, Spanish citizens moving to the UK, specifically looking at some of the succession and IHT implications of cross-border wealth planning. Obviously, many of those Spanish individuals come to the UK under a special tax status of being resident non-dom. Perhaps you could just set the scene for us on succession planning.
Okay, well, most of the cases that I've been dealing with recently are those Spanish nationals that, for example, well, there are two types, I would say. Ones that they come to the UK, for example, for career opportunities, and they stay for a period of time, and they don't become deemed domiciled. So, for example, they stay, say, 5 years, 6 years, but in the meantime, they start acquiring real estate in the UK, or they have considerable sums of investments. So, for example, in that case scenario, what is very important is because the Spanish clients, in terms of inheritance tax, they have, it's a total different system in Spain, because in Spain, the inheritance tax is paid by the beneficiary. There is no such thing as the state paying its own tax. So, for example, cases that happen are, for example, when Spanish clients, they want to transfer part of their wealth, after their death to their children, thinking that the same rules that apply in Spain apply here in the UK. So, for example, that spouses and children or descendants in Spain, they have the same tax consideration generally for inheritance tax purposes, but here in the UK, it is not the case. So, for example, it will be a matter of informing the client that if there are UK assets and the UK assets are taxable because they are over the nil rate band allowance, that they should consider that on the first death, assets pass to the surviving spouse, or if they don't want to, or for example, in trust to the spouse, and then it passes to the children. But another case that is very recurring is the number of Spanish nationals that are trapped by the ding-dong rules, and they even relocate back to Spain, but they are still trapped by the rule. So, for example, I had cases of people that have Spanish people that have been living in the UK for 30, 40 years. For example, typical case of a Spanish lady or a Spanish gentleman that they've been living here for 30 years. They were married to a UK national. Sometimes, in most cases, they don't have children, but they want to relocate back to Spain to be close to their family. So they are trapped by the rules in terms that, for example, they die within 2 years or a year after relocating to Spain. And all of a sudden, the beneficiaries, they are faced with the reality that the state is subject to, the worldwide estate is subject to UK inheritance tax. So in many cases that comes as a surprise, because there are cases where there are no UK assets left because everything has been liquidated and sent to Spain. Other cases, there are UK assets still, and we have to go through because there is no double tax treaty between Spain and the UK for inheritance tax purposes. So we have to go through the unilateral tax relief that I've dealt with both sides in the UK and in Spain, and it's not very straightforward. Well, in the UK, I would say it's easier. In Spain, it can be can take a little bit longer, but you can have situations which is because depending on the autonomous region in Spain where the beneficiaries are tax residents, where the tax payable in Spain on the worldwide estate is much lower than the inheritance tax being paid in the UK. So you can be, for example, if it's in Madrid and children are inheriting in Madrid because they are tax residents in Madrid, they may have a very small tax bill to pay, but they may see a large tax bill in the UK that cannot be offset in Spain. So, you know, you can have all sorts of case scenarios and you can make it as complicated as possible. But for me, one of the things that are very important when a Spanish client is purchasing or acquiring real estate in the UK, I would suggest that the client should be made aware of, you know, for example, I think that he should be asked or she should be asked what is their intention with their assets. So for example, if they buy a property in London, do they want this property as an investment? Is it going to go through the family? Because, for example, if the property at the end of the day is going to go for the children, because the parents are buying a property in the UK for the kids, you know, because they are moving to the UK, they are going to do their studies, or they are going to be working here. Perhaps it's better that the property is already purchased in the name of the children, or that the parents consider lifetime planning, lifetime gifting. So, for example, assuming that they survive, you know, the 7 years, you know, they can start doing, you know, not maybe, you know, they don't have to give the entire property, but, you know, start gifting shares in the property. There are various ways around it, but it is very important that, you know, dealing with a Spanish client, they should be made aware of the differences in taxation, because, you know, for inheritance tax purposes, you know, the burden is left on the beneficiary. Whereas here in the UK, you know, it's the other way around. Is the estate that has to pay the taxes, or the personal representatives on behalf of the estate. So it's also a shift in mentality, because so for example, in the case of a British person going to Spain, they're faced with the reality that in Spain there is no administration of an estate. We merely transfer assets from the deceased to the beneficiary. Whereas here in England is far more sophisticated, because you enter into administration of an estate and the beneficiary sits patiently waiting to receive a check for their, you know, for their share in the estate. Whereas in Spain, you pay to inherit. So it's, you know, a shift in mentality, basically.
What about the will planning? I mean, if a Spanish family, they buy a property in the UK, that's the only footprint in the UK. Do they create a will to how that will be devolved, or what do you see for will planning?
Well, my advice is, if you're going to have UK real estate, you have to have an English will. Because I've seen lots of cases where there's been the biggest family dramas you can ever imagine, because a Spanish will, you know, we do not appoint personal representatives. You can appoint an albacea, which is like a personal representative, but with very limited powers. They do, because as I say, the concept of administration, as you understand in the English legal system, does not have an equivalent in Spain. So basically, what will happen is that if you are using a Spanish will in the UK, one of the beneficiaries will take the grant, and he or she will be an administrator. The problem is that an administrator, contrary to an executor, cannot act until they have a grant until there is a grant of representation from the probate courts. So if a Spanish client is buying a property in the UK, I would advise that they have a UK will, appointing executors, that the will, you know, can be worldwide or limited to the UK. But on the other hand, if they have a Spanish, for example, if they have a Spanish assets and it's a straightforward estate, I would advise that they have a UK will for UK assets and a Spanish will for either worldwide estate excluding the UK, or a Spanish estate only.
And what about disputes? I mean, I imagine beneficiaries are caught by surprise by a lot of the differences between the laws with families with assets in Spain and the UK. What happens on the dispute front? Do you find beneficiaries coming to you trying to claim things are unfair?
I think that dealing with a dispute in an estate, I mean, and if any colleagues today have been dealing with a dispute, you end up being the psychologist, the psychiatrist, the friend, the crying shoulder of the client, because basically what happens is that I've seen cases that, for example, siblings that they have inherited from a relative, they are Spanish, there is a Spanish will, and one of them goes to a solicitor. The solicitor says, well, you take the grant. And we are facing a situation where one of the siblings is the personal representative, has full control of the estate. The slightest dispute between them, for example, one wants one thing, the other one wants another, ends up being the personal representative having full control, and is non-disputed that person has full control. And, they can make each other's life miserable. And I've seen cases of very small estates that they have racked into very large legal bills because of disagreement between the parties. It all always starts with, this is a matter of principle, and it ends up being, a matter of an extremely large legal bill for the parties involved. And yes, I've seen lots of disputes when when the will has not been properly drafted, or again, the misconception of the role of the personal representative, because a Spanish person, when you're dealing with their estate, they think that the beneficiary has full control, because in Spain is the beneficiary that has the control on the estate, and here is the personal representative. The beneficiary here is just a mere spectator of what is going on, basically.
Thanks. And on trusts, we heard from Constantino that trusts aren't an effective tool in Spain, but many non-doms approaching deemed domiciled, they're 15 out of 20 years, would use a trust. Do you find that the Spanish origin clients just avoid trust for structuring and do something else? Or?
Well, I think that the word trust and Spain should not be used in the same sentence, because it's the perfect recipe for the disaster. One thing is having been the beneficiary of a trust in Spain, yeah. And Constantino will explain how the tax authorities in Spain will whether you are how you're going to be treated. But in Spain, when you, for example, I've seen many cases of British nationals that they have a will constructed in such a way that the Spanish assets are in a trust. And basically the problem you have is that because the trust is not recognized in Spain, we are not a party of the Hague Convention of Trusts. You tell a notary or a land registrar, excuse me, that this property in Spain is being left in trust, and they will look at you like if you are speaking a total different language, and what is this? And they will have to resort to similar formalities. So, for example, what I would urge any lawyer that has a client with Spanish assets and they have a UK will, to carefully review that to avoid that the Spanish assets pass in trust. They can always keep, for example, it can always be left in a legacy clause if you want to keep it simple in one will only. So, for example, leave the Spanish assets in a legacy clause that has been supervised by a Spanish lawyer, because some lawyers can get very carried away when they draft legacy clauses, and it can be too Shakespearean for a poor land registrar or a notary public. So, yeah.
There's a question here from Lucia St. Clair from Casino. Thanks, Lucia, for your question. It's not fully formed, but I'll ask you, Alvaro, and we'll see if we make sense of it. It's useful to know implications of cross-border gifting. So I suppose, is that a setup with the Spanish family gifting into UK, for example, adult children, for example, on that property purchase? What would some of the headlines be around that, where the gift is going to?
Well, a typical gift scenario that I've seen is the Spanish parents gifting money to their kids in the UK to, for example, a deposit in a property. And it will all depend whether the beneficiary is a tax resident. If the beneficiary, the child, is a Spanish tax resident, he or she will be liable for gift tax in Spain. But if they're tax residents in the UK and they can prove that they are tax residents in the UK, in principle, there should be no Spanish gift tax. And here in the UK, there will be, I would not think that will be considered as a pet, a potentially exempt transfer, because the donor itself is a non-UK tax resident, non-UK domiciled individual. So it should not be accounted in the estate for inheritance tax purposes in case that person doesn't survive the 7 years of gifting. It is very common for Spanish families that they give their children, to help to buy the first property in the UK, and they gift sums of money here in the UK.
Okay, well, thank you, Alvaro. We're going to bring Paula back in on that point, actually, because, if you've got wealthy Spanish family, you've got young adult children in London wanting to buy a flat, perhaps cohabiting with a boyfriend or girlfriend they've met while in London. What are the some of the family law considerations you think about this kind of setup?
Well, actually, yes, absolutely. If the couple is not married and they are living in the UK, then it should be easy in the sense that they could sign a deed of trust, declaration of trust, when they acquire a property. If the money comes from the family of one of the couple, then they should make clear that perhaps upon sale of that property, that money needs to be returned or reimbursed to one of the parties. So, and from the UK perspective, they will be protected as long as they don't marry. That declaration of trust will stand in place. What happens when you have a couple that considers marrying, Spanish couple that moved to the UK considers marrying? Well, the best advice I could give is don't get married. But if you still want to get married, then you definitely need to obtain legal advice and understand what will be the financial consequences, not of marrying only, but of divorcing in the UK. And the reason being is because if you come from a wealthy family, yes, I'm sure the family will have their own structure to protect the assets. But for example, you might have actually been married in Spain already. And as part of the protection of the assets, you have entered into a separation of assets regime. Then you move to the UK and you think, I'm protected. I've got a Spanish marriage contract, separation of assets, it's mine. Well, I have to say, unfortunately, the UK courts are not going to be bound by that Spanish marriage contract of separation of assets. What might end up happening is actually the opposite, that all the family wealth, if it has been mixed with your marriage, if you are using the income that your parents' wealth is generating to live out of it, is going to be part of that distribution of the assets. So again, what can you do? Do either a prenuptial or postnuptial agreement. They're not fully binding to the UK courts, but they're one of the circumstances to consider in the breakdown of the marriage. And as long as you keep that document updated according to any change of the circumstances, you will be protected. That's the best protection that can offer.
Because they could have, for example, shares in the Spanish family company that yields a dividend, and if they move to the UK without consideration of that, that could then come as part of the divorce proceedings.
Exactly, because I mean, it's in that case I will specifically mention that in the prenup, and I will mention those shares. But of course, you still need to be careful, because if those shares generate an income that you live out of it, or you buy property out of it, it might still have to be part of the divorce, unfortunately. So it's important to be careful in that regard. At the same time, for example, one of the points to consider is that in the UK, there is no concept of cohabiting couples, as in having any rights and obligations towards each other. Children is another matter. But for example, in Spain, in the specific area of Catalonia, Barcelona, just because you have a child together, or because you have been cohabiting for a period of 2 years, certain rights and obligations will arise. So if you're from Barcelona, you might think, oh, I'm protected because of this law, but then you move to the UK, you have nothing in place, and if you separate, you won't be able to make any financial claim if you're not married. So from the less wealthy party, it might be also advisable to consider entering into a cohabiting agreement.
Okay, well, thank you. We've got a question there, Paula, for you from Katia, just asking, So a Spanish national relocating to Spain this summer is married to a UK national in Gibraltar. Spain doesn't recognise Gibraltar's civil marriages. So what do you recommend? I'm not sure if you recognise the setup there, but just asking making the point that is the civil marriage that took place in Gibraltar recognised in Spain? Is there anything that they should think about around that in terms of the planning for relocation?
Yes, I'm not sure why it says that Spain doesn't recognize the Gibraltar civil marriage. I've never heard of that. It's interesting. I would like to find out. But in any event, usually what happens is when you are a Spanish national and marry abroad, ideally you should register that marriage either in the consulate of that foreign country or at the central civil registry in Spain. You should register that ideally. If not, it shouldn't be a problem.
So maybe take that one offline and see if there's any extra detail that you can get out of that. We've got another question from a follow-up question. Actually, I'm going to bring Constantino back in on from John Hilson, just asking as a follow-up to the Brits working from home but doing so remotely in Spain. Is there an application process around residency that they would have to go to? I appreciate you're a tax lawyer rather than an immigration specialist, but what should they be thinking about to formalize that? If they are spending more time in Spain, how can they go about making that more formalized?
Well, it's important to know that the tax residency, it's completely different from the civil residency, which means that for obtaining the residency here for tax purposes, you don't have to do basically nothing. Yeah, it's something that it's a matter of fact because you meet the requirements, you will be considered as tax resident in Spain. But it's also important if you want to show that you are in Spain, you have to inform to the Spanish tax authorities that you are here. So basically you have to submit a tax return, that is the 30 tax return, saying, hello, Spanish tax authorities, I'm here, I'm going to work from home, but I'm going to spend some time here. So I'm going to be a tax resident in Spain. And that's basically it. It's, as you can imagine, it's very straightforward. We all want new tax residents for Spain.
Okay, absolutely. Well, John, I hope that helps with your question. We're going to come to a close in a second, but I just wanted to come to Alvaro just to wrap up this session. And what are some of the key thoughts that this audience is tuned in for today, Alvaro? What are the key takeaways do you think people should be looking at, both from a UK and a Spanish perspective?
Well, to me, I don't want to sound negative, but there is no such thing as a straightforward cross-border state or succession. There are lots of devils in the detail. Secondly, it will be never assumed that what happens in your jurisdiction is going to apply in the other jurisdiction. And I would say as well, when you're dealing with, for example, a Spanish client, it will be good to understand the differences in the system, so the client so you can relate better to the client in order to explain the differences as to how things happen in their new jurisdiction. So I would say those are the three key questions or three key points for me. Basically.
Perfect, thank you. Well, contact details will follow to our Zoom audience for all our panelists so that you can take up anything online specifically with them around specific scenarios. But thank you to your questions today. They've been terrific. And